deposits, one from 5/17/01, correct?
Yes.
And that was about $10 because she took out $200, correct?
Dollars and some change, $10.80 dollars, and $10.80 cents and change.
And there was another one for 5/22/01, correct?
Yeah, if we're going to go through them in detail, do you want to display them or show them to me?
If I wanted to do that, I will do that. I'm asking you questions about them. Do you remember that one?
I remember the statements, yes.
Now, we had talked about the fact that there was probably 11 or 12 checks that she may have gotten within that time period, correct? From
Yes.
starting in December to working till May.
Yes, every 2 weeks she is paid.
And I asked you specifically if there was any other checks deposited in that time frame, correct?
Correct.
And you said no.
Not that I'm aware. The deposits I have not seen to be her full and complete check.
There was a deposit in about December of 2000, correct? From Alissa. There's I believe, a slip that comes up with that.
Yes, that has her signature on it and her stepfather's driver's license on it.
Yes.
That one? Yes.
So that was a deposit and some money withdrawn also, correct?
Yeah, as is typical, yes.
But when looking at those records, there is not 12 transactions similar to that, is there?
I don't believe so.
And I believe altogether there was only 5 deposits between October of 2000 and May 22nd of 2001.
Is there a question there?
There was only 5, correct?
That would appear correct, yes.
There is a bunch of other deposits we talked about in the amount of like $1 or $2 that periodically happened, correct?
Yeah, that would appear to be the interest accruing on the account adjusted into the account.
And there was about 30 of those.
I honestly do not know the number of those.
Okay.
Smaller transactions.
Now, I want to ask you specifically about some phone records of the Turney home. We found there was some discussion with Detective Summershoe about phone records or phone bills, correct? And I believe when the questions were asked to Detective Summershoe, those two words were used interchangeably, correct?
Yes.
In the police world, do you have a different meaning for those two things?
Yes, I do. Yes, I do.
And what is a phone record in your reference to that? If you were to put phone record in your supplement, what would you mean?
A bill is something that we found at the scene. It's a document where you are being billed by the company to pay for your services. There is a small volume of information included on that to explain the charges you are expected to pay. When law enforcement subpoenas records or obtains records through search warrant, I'm expecting a much more complex, much more detailed document. I don't care about how much you're paying. I'm interested in the activity itself.
And I guess it would be safe to say, looking at the phone bills from that time frame of May and June, on a home phone, there's not every single call listed, correct?
No, it's only the calls going out from the home. I don't think they show your calls coming in.
Okay. And are you aware of any calls on the evening of the 16th between the Turney home and John Lackman's number?
I'm sure that Alissa was speaking to her boyfriend prior to the 17th. I'm not aware of any detailed contact.
So there's nothing on the phone bill that would indicate that on the 16th she spoke with him, correct?
Not that I recall.
How about on the 17th in the morning? Is there anything that you remember about that?
No.
The first contacts that appear on the phone bill seem to correspond with Mr. Turney calling and leaving Mr. Lackman a message, correct?
Mr. Turney calling and leaving Mr. Lackman a message?
Yes, in the
early morning.
No, in the evening. On the phone bill there is some reference of an outgoing call to that number, correct?
From the Turney home to Lackman, yes.
And we heard Lockman say that Mr. Turney left him a message. That would be consistent with that, correct?
That's correct. He was working at U-Haul. He worked late shift that night.
Okay. Now, I want to ask you about the video recording of John Lakeman and Alissa, correct? You're aware of that video. That video has been shown in this court, correct?
I'm aware of several copies of that video, yes.
Are you aware of any statements that Mr. Turney made on why that was recorded?
Yes.
And what was that?
Mr. Turney portrayed Mr. Lackman as violent and a danger to Alissa, somebody that Alissa was afraid of and was actively trying to end the relationship with. Mr. Turney stated he had kept that video to confront Alissa, to discuss the violence.
Did he ever say why it was recorded? Did he ever, in an interview, ever say why it was recorded?
Why it was recorded?
Or how it was recorded?
The security at the home was a constant.
Well, in fact, did he not say in that same interview with the narrator where he's been asked about that recording, he said, well, I did not mean to. I went to bed and I turned on the tape like I always do for the cameras at night. And then I realized that Alissa still had her friend there. Okay, then I got up and told him, you need to go.
That is not Lackman. That's the Michael Stanley incident that he's referring to at that point.
Yeah, that's the video of the Stanley inside the home, correct?
Yes, I'm sorry. I thought you were talking about John Lackman, where John Lackman and Alissa are involved in that alteration, and he leaves the home.
Yeah, and in that particular video between Lackman and Alissa, there is 2 tapes of that also, correct?
Yes.
And is there one that has more footage than just the one that you received?
It's possible that there's a little more footage on that, yeah.
And actually, that was turned on mid-argument, correct? There's nothing prior showing the 2 of them in the house arguing.
I do not know when that was turned on.
But on the video that you saw, is there any argument inside the home between Mr. Lackman and Alissa?
No, Mr. Lackman stated that Michael Roy Turney stopped him as he entered the home and then told him that she's cheating on you. That's what provoked the argument, but there's nothing captured with Alissa and Lackman arguing.
Is there in that video where Mr. Turney and John Lackman are in the carport where that conversation supposedly took place?
I am not sure.
You were present while Detective Summershoe testified last week, correct?
Yes.
And he was asked, has Phoenix PD ever received any information about Alissa being seen, heard, or found since May 17, 2001? And he answered no. Do you remember that?
That's correct.
Now, over the years, there has been information provided to PPD about Alissa, correct?
About Alissa? No, about possible sightings, possible leads, things like that, but none of them have materialized to the point that we can say Alissa survived May 17th.
I agree, but you agree that people called in and at least said that they had saw Alissa?
Oh, absolutely. After that ABC, that was 6 million people that viewed it that night. Detective Summershoe and I both spent the next couple of days taking incoming calls.
Some of them you investigated, others you did not, correct?
That's correct.
Now, as a detective, is it common to work with police officers from other cities? Sometimes, if you need help?
Yes.
And sometimes they'll call you asking for help in a situation in Phoenix where you can go collect some evidence or do something, correct?
Routinely, yes, absolutely.
And you are aware that you can do the same thing with them, correct?
Certainly, we have on multiple occasions.
We talked a little bit about, during your investigation, you reviewed hours of videos, including surveillance videos, correct?
That is correct.
Now, we talked about the layout of the Turney home a little bit. And you discussed where the cameras were from your vantage point of videos that you saw. One was outside in the carport?
Yes, outside in the far corner of the carport. It was an unenclosed carport at that time. The house has been since remodeled. That camera was pointed towards the main door on the interior of the carport.
And one was inside, which faced the couch in the living room, correct?
Yes, elevated position, an air conditioning vent, and then facing down to capture the living room, specifically at that couch.
Did you ever come across any surveillance videos that you reviewed which showed recordings from the other side of the house?
The exterior, the backyard, yes, I think we have some that are dated later, but I believe those to be the 17218 house.
Yes, I'm talking about in the house where Alissa ran away. Did you find any videos of the backyard or the side of the house?
There are videos of the backyard, and I don't remember the side of the house, but the backyard when they had a trampoline, family videos.
Yes, that's someone recording on a camcorder.
Yes.
Is there any video surveillance that looks like it's just showing that there's a still camera capturing that area?
There is some that show a workout area. There was a bench set up, and there's some tarps hanging down.
What about the front two windows of the house? Is there any cameras pointed at those windows?
No.
Based on your recollection, are one of those two front windows to Alissa's room?
Yes.
Is there any video footage from a hallway where Alissa and Sarah's bedrooms were?
No, no video footage showing the hallway.
Now, as part of your investigation, you reviewed the Starbucks recorded conversation that Sarah recorded, correct?
Yes.
You heard the deathbed comment?
Yes.
You also heard the defendant say that if she came back, she would get the same answer, correct?
That's correct.
As she knows right now.
That's correct.
He also told her on several occasions that he couldn't confess to something he didn't do.
Yes.
Now, during the discussion in this case, and we went through a little bit of numerous letters Mr. Turney wrote and numerous recordings on the phone. And so I just kind of want to do a little bit of, I guess, time frame of when those occurred. So you can, if you remember, if you need me to refresh your recollection, I can bring you a copy of that. But
I'll do my best for you.
So first I want to ask you about the phone call that was played, the one between Mike Sr. and Jr., where he is describing Alissa. He's at his end with her. He's worried about, calls her a bitch. Do you remember the call I'm talking about? Do you remember the call I'm talking about?
Yes.
Do you know when that call occurred?
On the 28th.
Of what?
I'm assuming it's April 28th, but I do not have any way to take that recording and establish it.
Now, he says the 28th.
Just for completeness, we've got a month and a date, but not a year.
Well, I'm getting to that, and I don't think we'll ever know the exact year, but I'm going to try to clear that up a little bit. There is some talk in that conversation about the 28th, and it's a bad time for him, correct?
Bad day, yes.
Yeah. Are you aware when Barbara died?
1993.
February
Yes.
28th?
February 28th, 1993.
Yes.
Yes.
There's other reference to that February 28th date in other conversations, correct?
To February 28th, yes, the date of her death.
So in that conversation that he's having with his son, there's mention of this 28th, how it's a bad day and stuff like that, correct?
He gives specific reasons for it being a bad day in the
Yes.
call.
Yes, he specifically says the 28th is a bad day. And then he goes on in that call. And if I'm to get that correct, I believe he's talking about him finding drugs on Alissa, correct?
I think the biggest part of the call was her refusing to bond back with the family and him feeling he needed to call cops to address a drug issue.
And specifically, he's referencing something of $750 to $1,000 fine. He'd have to turn her in, something he would never want to do to any of his kids.
Yes. Going to lose the house.
Now, we had heard testimony from witnesses in this trial about Alissa having memory issues, correct? Do you remember?
We've heard from Mr. Turney.
We've also heard from Sarah. She said that in the interview with you, correct?
She stated it in her initial interview, yes.
She told you in an interview that Alissa had memory issues, correct?
Correct. She said that in her initial interview.
But she told you in an interview, correct?
Yes.
Michael has said that also in communications with detectives over the years, correct?
Oh, yes. Many times he's described her as having a mild form of retardation, her frontal lobe.
Objection, non-responsive, strike answer.
Sustained, counsel, when you're asking about Michael, are you asking about the defendant?
Yes, Michael Sr.
Okay.
He also mentioned that in the letter on May 25th, 2001.
Yes.
And as part of your investigation, you came across communications that predate Alissa's disappearance, correct?
Yes.
And you reviewed documentations or communications where Michael Sr. has claimed these things before Alissa ever went missing, correct?
Correct.
So him making claims that she has a memory issue isn't something that he brought up after she disappeared, correct?
No, correct, yes.
Now, there are plenty of communications with Mr. Turney had with school officials predating her disappearance, correct?
Correct.
With his concern about her academically?
Correct.
Discussions about his expired IEP, correct?
Correct.
And one of those such discussions was February 7th, 2001, correct?
Yes.
He also mentions drugs in the home in that February 7th communication, correct?
Found marijuana under a couch, yes.
And February 7th would be approximately 21 days before February 28th? 3 weeks?
Say exactly.
Okay. This IEP and subsequent memory issue is something that he brought up many times after she went disappearing, or she went missing, correct?
After she was reported missing, yes.
And also predating back years, correct?
Yes.
There are also discussions of Alissa going to live with John and Mike in 2000, correct?
In May of 2000, she did go to live with John and Mike.
And there is the signed subsequent documents pertaining to this that we've discussed in this trial, correct?
Rental custodial agreement signed in May of 2000, correct?
One was signed May 19th, 2000?
Yes, I believe so. Was it? Okay, yes.
There's another document that is 5/27 of 2000, is that correct?
That's correct.
And then there is the revocation of that contract on June 2nd, 2000, correct?
Yes.
Now, we talked a little bit about the phone bills that were recovered. There's also been mention of an AMA dump or an AMA. What does that mean to you?
That is the phone record provided from Quest.
Okay. But what does that AMA mean?
AMA dump, I don't know what the acronym stands for. It's what their engineers put together to provide us the complete history of that particular device, that particular phone.
And that's what was done when he requested the records or attempted to sue them for the record from the 5/24. And I say he, Mr. Turney, the defendant in the case, 5/24/2001 call, correct?
That's correct.
Now, one of those phone bills from July documents what happened the previous month, correct? So if you get a bill that's dated July 17th, that's not for July records. That's for the previous month, correct?
It's a post-event billing. So if they bill you on July, it's for the month of June. If they bill you in June, it's for the month of May.
And when we discuss those roaming charges with the calls from California, that would reference a July bill, but a June event, correct?
Correct.
Now, in regards to the AMA dump, it seems based on what you learned that those records were received July 3rd, 2001, correct?
I don't remember the exact date, but yes, the first week of July is when Mr. Turney received the records.
Would reviewing your police report help refresh your recollection?
You could simply read the date off of it. I believe that. I simply don't remember the specific date.
Now, also as part of your investigation, did you review any records or notes from Detective Schoenfelder about doing anything with the information that Mr. Turney, Michael Sr., gave him in regards to that call from California?
No.
Do you know if Detective Murphy did anything about that communication when she came on the case in 2004?
Nothing was documented regarding that May 24th call.
No. Do you have your supplements in front of you?
I do not.
May I approach, Your Honor?
You may.
This is not a touch screen.
Yeah, it is. What are you trying to do? Make it bigger.
I'm just trying to move it up. Page 971. All right.
It's paragraph 3 and 4.
Paragraph 1, 2, 3. All right, so this is from Michael Turney saying what he did.
Do you agree that that says July 3rd, correct?
Yes, it says July 3rd. Yes, I'm sorry. We were doing that to argue about the date?
No, I'm just.
Yes, July 3rd.
As part of your investigation, there was communication between Mr. Turney and someone where he referenced getting the documents on July 3rd, correct?
Yes.
And I think other times he had said that it had taken about 6 weeks to get those documents.
That's correct. And going from May 24th to July 3rd would seem to be 6 weeks.
About 6 weeks.
Yes.
So also as part of your investigation, you received or found a receipt from the Best Western in Moreno Valley, correct?
Yes.
And that receipt was for a trip between 7/5 and 7/7, correct?
July, that's correct.
2 days after receiving the phone dump, correct?
Yes, I believe that's when he and Sarah went.
Now, we have heard testimony about Lynette, who lived in California, correct?
That's correct.
Do you know whereabouts that she lives?
I don't remember the exact address, Torrance.
Torrance. And that's near that area, within 50 miles?
About 70 miles,
70 miles
away from the location of the phone call.
Now, there's also been talk, and you learned through your investigation, that Alissa had family that lived in Oregon, correct?
Yes.
You have documentation and letters that were sent to Columbia County Sheriff's Office from 7/9/2001, correct?
Yes, those were prepared by Mr. Turney.
And he sent them to the Oregon Sheriff's Office and enclosed a missing person flyer, correct?
Correct.
And that was shortly getting back from California, if he was there from the 7/5 to 7/7.
Would appear to be.
And on 7/10, there's a letter to Detective Sean Felder documenting the letter he sent to Oregon and included a copy of that letter, correct?
Yes.
And in that letter, he talks about a description of a man.
Mm-hmm.
That man was Paul Abbott.
Is this getting into hearsay? Sustained.
You reviewed the letter sent by Mr. Turney, correct?
Yes, it was part of the original case.
And he's giving information about Alissa that he had found out?
He is showing information that, yes, that he's sharing with detectives.
And the general gist of that is that it might not be significant, but I'm just trying to pass on this information.
Correct.
And he specifically references that at this point it's just a runaway,
Yes.
but it's my daughter, and I can't help but worry.
Yes.
Then on 8/30/2001, he contacts Congressman John Shadegg,
John Shadegg, yes,
Shadegg?
through Bruce Radin.
and this letter he's being very critical of police investigation, correct?
Absolutely.
He's asking for help in Alyssa's runaway.
Yes.
So that's in August of end of August 2001.
2001, yes.
Also, as part of your investigation, you reviewed recordings, correct, of conversations that Mike had.
Yes.
One of those such recordings was on September 25th, 2001, with Sergeant White from the Phoenix Police Department, correct?
Sergeant Bob White, he was the original missing person sergeant at the time she was reported as a missing person.
And he's being critical in that of how the case is being handled.
Yes, he yes,
And he's specifically talking about how vulnerable she is on the street,
yes,
trying to invoke someone to investigate his daughter's case.
yes,
He becomes emotional in that recording, doesn't he?
yes.
He actually starts crying.
Sobbing, yes.
I just want my daughter back.
Just want her back.
And in another letter dated 12/20/2001, he contacts another sheriff's office, correct?
I don't remember which one that was.
Kings County Sheriff?
Kings County, Washington,
I believe Kings County is in California.
California.
But in that letter, again, he is giving them information, correct?
That's correct.
He sends them his NCMEC letter
His
and a
NCMEC
copy.
letter? Yes.
Sorry?
His NCMEC letter.
Yep. And a copy of a missing persons flyer, correct?
That's correct.
Then in January 16th of 2002, he sends another letter to NCMEC, correct?
Correct.
And then on February 22nd, 2002, he speaks with Sergeant Roberts again, correct?
Sergeant Roberts is the new supervisor, the one who replaced White.
And so he talks to him on February 2nd, 2002, and he's discussing Alissa, correct?
It's a her, but yes,
Oh, I apologize.
that's right, Mary Roberts.
And then in May 28th, 2002, he writes a letter to the Department of Labor.
That's one of many written to the Department of Labor.
But this one is specifically discussing his daughter,
Yes,
complaining about the lack of action.
yes,
That is in May. That's about a year after she ran away, correct?
just shy of exactly a year.
Or just more? 5/28.
5/28, yes, 11 days passed.
Now, there's some other interactions between 2002 and 2003, but in March 2003, March 13th specifically, he contacts the DEA, correct?
Yes,
And then on 3/17/2003, he writes a letter to Sergeant Robertson outlining the things he has done and his suspicion of people he has contacted.
Sergeant Roberts,
Yes.
yes.
Robertson, I believe. Is it Roberts?
Robertson, should be Sergeant Mary Roberts still.
want to double check. You are correct. Detective Roberts, or Sergeant Roberts.
Sergeant Mary Roberts, yes.
Now, from May 2001 to March 17, 2003, there's no reports or anything from Detective Schoenfelder outlining any follow-up on any information that he was given.
Correct.
No one had heard from Alissa in 2 years at that point almost?
Yes, she's turned 18 and they still have not altered their approach.
Co-workers?
No contact with her coworkers, no contact with Barry Goldwater students, no contact with Paradise Valley students, no canvass of her neighborhood.
But the letters don't stop there, do they?
They do not.
He contacts Chairman Boerner, Boerhner, on June 17, 2003, correct?
Yeah, that's Boehner, isn't it? Boehner?
I don't know. That's why I spelled it. I don't know. Is that, I mean, are you familiar who that is?
Yes.
And he contacted them, correct?
Yes.
And then in about the beginning of 2004, it looks like that's when Detective Murphy takes over, correct?
I believe so.
And between 2004 and 2006, there's communication between Detective Murphy and Mr. Michael Turney, correct?
Mr. Michael Roy Turney, also with John Turney.
So there is some contact between them. He's giving them information. There's some of the things about dental records and all that happens between that time, correct?
Yes, before Detective Murphy, there was no way to identify or legitimately compare any unidentified human remains with that missing child. So Detective Murphy reached out to try and create that pedigree.
And then on December 4th, 2006, there's a call from Detective Murphy and Mike Turney discussing Alissa's case.
That's correct.
And then we get to January 1st, 2007. There are other calls reference Alissa's case with the Congressman Sean Shadegg or Shadegg?
John Shadegg.
Shadegg,
Yes.
correct?
Yes. And it's not with the congressman, it's
With
with
the aide.
his aide, Bruce Radin, who I interviewed.
Okay. And then on January 1st, 2007, there are other calls reference Alissa's case when he contacted Senator John Kyle's aide, correct?
Correct.
And he's asking them to help about his case,
Yes,
get word out about Alissa.
absolutely.
He also goes further and contacts Janet Napolitano's office too, correct?
I believe he did. I don't have any recordings of that. I think that was a letter.
And she was the governor at the time,
She was.
and he's discussing her case, trying to get action.
Yes.
Then in February of 2007, there's contact with the FBI in reference to Alissa's case, correct?
Correct.
And then April 15th, 2008, contact with NCMEC again, correct?
Correct. NCMEC contact was fairly consistent.
But even as much as April of 2015, he's still complaining about the investigation.
I'm sorry, April of 2008 or 2015?
2008.
Okay.
2008, yes.
Still complaining about the investigation, complaining about what has not been done.
Correct.
And in 2007, there are more calls where the defendant September 18th, 2008, correct?
Yes, that was the in-person interview.
And that's where he gave you, when you went to the house, I guess, and he gave you the recording of the argument between Lackman and Alissa.
Yes, let me correct my statement. The first contact I had with Sarah was September 12th. At that time, I arranged to have that in-person meeting to go to their home to collect evidence, and that was the 18th.
Okay. And that's when you came to the home?
Yes.
And he gave you that recording. That's the one
Marked 5-6.
The other video that was found in the house is the one that's marked 516.
Yes.
And would you agree, looking at those two tapes, that the one on that was given to you on September 18th looked like a fresher pen? You could read the writing more clearly, correct?
I had to go back and collect that tape at a different date, but yes, it was the one mentioned and the one offered that day.
Okay. The one that was found in the house looks like it had faded a little bit. It was with whiteout on it.
Definitely looked more used, yes.
No further questions at this time. Thank you, Your Honor.
Thank you, Mr. Jackson.
Mr. Anderson. Detective Anderson. Sure.
Any redirect, Mr. Bailey?
One more, Your Honor. All right, you were asked a number of questions. Just to begin, there was some question about dental records. You obtained Alissa's dental records?
Not me specifically, but Detective Murphy did obtain her dental records. They're dated from 1997, so they're mixed dentition.
Okay, and I apologize, that was a poor question, but Phoenix Police Department had obtained her dental records?
Yes.
You noted that you were asked about some reports. Was there national and media attention that was provided to this case?
Absolutely.
And was that the ABC primetime video that we have seen?
No, it was before that. There was national media attention on the John Walsh show. She was carried in various articles that are nationally televised. Nick Mick did a fantastic workup with this child. There were race cars that had Alissa's face put on them to promote her investigation. The case was active.
and some unrelated issue?
Absolutely unrelated.
You were asked about how there was not a lot of work done initially by Detective Schoenfelder. You remember that?
I do.
Again, if you have a call that came in today where a parent says, my 17-year-old ran away from home, what action would you take immediately on that?
I am absolutely not going to lock down the border between Arizona and California in that situation. You have a 17-year-old person who knows how far she is away from being an adult. My only obligation there, the only thing I'm going to do is ensure that she's properly identified in ACIC and NCIC. There is no condition where you start looking for a 17-year-old kid who left a runaway note behind saying where she was going.
And if that same parent calls in a week later and says that they had heard from their child, what would that do to your urgency in investigating her?
Completely deflated.
Did you do did Detective did Detective Summershoe do a follow-up interview with John regarding domestic violence?
Yes, we had the initial interview with Lackman. Detective Summershoe performed that interview. We then talked to Alissa Turney, and she expressed having seen a potentially violent exchange between the two of them. So Detective Summershoe brought him back and conducted another recorded interview to specifically address that allegation. It is not true.
On the video of the fight between John and Alissa that we have seen a number of times, do you ever see, is there anything to indicate that John did anything physically violent to Alissa in that video?
No, I object to I object to it being called a fight video. The child's walking in to see his girlfriend. He's cut off by her father. The father says, she's cheating on you. She mentions that to Alissa. There's emotional exchange there, and the boy walks away. He gets into his car, and yeah, he peels out going down the street. He's relieving some stress, but there's no violence. There's no violence in that kid.
You were asked briefly about an individual named Paul Abbott. Was he investigated?
He was. I've had several conversations with Paul Abbott, and for the record, he was investigated by detectives before me. He was located by Detective Murphy.
You were asked, there was a comment about Alissa having sex with older men. Are the only two incidences that you're aware of with Michael Stanley that we've seen in the video?
That's not sex. That is a sexual, it is what it is. It's making out. He's the only person that we've identified that's had any sort of contact with her other than John Lackman. And it's easy to look down your nose and cluck your tongue at her for acting out in that way. But for law enforcement, my interest is asking what's causing her to act out that way.
The second incident that you're aware of was a year prior at John Turney, her brother's house?
Yes, there's a rumor that she may have hooked up at a party at that apartment complex.
If I call up and ask you to make a subpoena for me to get records, does Phoenix PD have the ability to be able to get just subpoenas, send out subpoenas for individuals?
No, I have no subpoena ability. I have no search warrant ability. I do not have magical powers. What I do is prepare an affidavit. If I'm investigating a crime and I can articulate to a superior court judge that that I believe probable cause that this crime has been established, a judge or the county attorney will issue a subpoena that I will serve upon somebody to obtain records. In the absence of the investigation of a crime, I do not have that ability.
Can you determine the location? Can you determine who is making a call from California?
No.
Can you?
I can't put somebody on that handset without a recording of a voice. I don't know who they're talking to.
So it could be anyone?
It could be anyone.
Were you able to determine if that call was a collect call?
No,
No, you weren't able to.
no, it was not a collect call.
And that was a call from a payphone?
Yes, that was a call from a payphone in California.
After this, Alissa disappeared on May 17, 2001. Is that approximately 5.5, 6 months before 9/11?
Yes.
Did 9/11 create additional requirements for financial transactions?
Yes, it did. It required that these institutions are much more responsive to law enforcement in those events that I have probable cause that a crime is committed.
And do financial transactions help you in locating individuals?
They do.
You were asked questions about the runaway note. Does the note ever state that it's a runaway note?
It is not a runaway note. It is a promissory note. It mentions an argument that happened sometime before. It does not conform to the events that happened on May 17th, 2001. It was kept from some time before that.
Objection, speculation. Detective has no information to back up his claim.
I'll sustain the objection as to non-responsive.
And I would ask that the response be stricken.
Your response is stricken.
May I follow up on that to make the record clear, Your Honor?
You can ask any question you'd like. If there's an objection, I'll rule on it.
Thank you, Judge. Does the note say that it's a runaway note?
No.
And to be clear, when we were talking about subpoenas, you did get a search warrant for the defendant's house in 2008 when you took over the investigation?
I did. When I took over the investigation,
I'll just leave it at, sorry, sir.
Yes.
Is that a yes?
Yes or no? Yes or no?
No additional questions, Your Honor.
Thank you, Mr. Paley. Ladies and gentlemen, any members of the jury have any questions for this witness? It appears that there are none. Thank you, sir. You may step down. How would the state like to proceed?
At this time, Your Honor, the state rests.
All right. Ladies and gentlemen, I'm going to take up some legal issues with counsel. I'm going to guess that it's going to take about 20 minutes. If I am wrong and leave you waiting in the jury room longer, I'll apologize, but we'll bring you back in as soon as we can. So I'll send you on break for 20 minutes. I'll ask you to be back in the jury room at 11:30. Please remember the admonition. You can leave everything in the courtroom. The jury is now excused. And counsel, I need a 2-minute recess. So I'll be back on the bench in just a moment. the record in State versus Turney. Let the record show the presence of counsel and the defendant. The jury is not present. Mr. Jackson. Ms. Hicks.
Your Honor, defense has a Rule 20 motion. Would the court like us to address that first?
I see your Rule 20 and your motion to dismiss, or in the alternative, suppress statements for lack of corpus delicti, as very closely tied together. So I'm happy to hear argument on either or both together.
Wonderful. Judge, pursuant to Rule 20, the court must enter a judgment of acquittal if there is not substantial evidence to support a conviction. The case law defines substantial evidence as that which reasonable persons could accept as sufficient to support a guilty verdict beyond a reasonable doubt. Now, defense is asking for this court to enter a judgment of acquittal based on three grounds. The first is that there's been a general failure to present substantial evidence to support a conviction. The second is that there's been a failure that the state can establish jurisdiction. And finally, a motion to dismiss based on the doctrine of corpus delicti. Starting with the first point, the state has not presented any substantial evidence that Alissa is deceased and that Mike caused her death. The state's case rests entirely on speculation, character evidence, and rumors. This entire trial has been about Alissa and Mike's relationship, what kind of teenager Alissa was, whether they had an acrimonious relationship, whether Mike was a bad parent, or if he was paranoid. There has not been a shred of physical evidence in this case. No body, no crime scene, no blood spatter, no body parts found in the house, no murder weapon, no evidence in the houses or in the car to suggest that a murder took place. The fact that Mike's home was searched 7 years after Alissa's disappearance has everything to do with the Phoenix Police Department's failure to investigate this case. Mike was the one who pushed the police to take a more aggressive approach to find his daughter. He did his own investigation. He worked to draw attention to his daughter's disappearance. Now, the state points to Mike's relationship with the Phoenix Police Department as evidence of his guilt. He was either too involved or not involved enough in the police investigation. The state cannot use Mike's involvement with this investigation, or lack of involvement, as a sword and a shield. Now, although defense does not have to prove innocence, there is sufficient evidence to show that Alissa ran away. There was testimony from Alissa's family and friends who described her as a free spirit, someone who was impulsive, stubborn. Mike was strict and controlling at times, and Alissa did not do well with rules. Alissa had a bank account that was set up by her father, and there's no record of at least 5 months of her paychecks being deposited into that account. Alissa had a fight with her boyfriend and cheated on him right before she went missing. There was, of course, the call with Aunt Lynette that happened at least 6 weeks before Alissa's disappearance, where she said, "You can always come see me." Finally, we have the runaway note, and then the call from California a week later. The state has not presented any evidence that Mike had the mens rea that's required for a conviction of second-degree murder. The state must prove either, 1, that Mike intentionally caused the death of another person, 2, that he caused the death of another person by conduct which he knew would cause death or serious physical injury, or 3, under circumstances manifesting extreme indifference to human life, he recklessly engaged in conduct that created a grave risk of death and thereby caused the death of another person. The risk must be such that disregarding it was a gross deviation from what a reasonable person in the defendant's situation would have done. I mean, we sat through 5 days of trial and the state has not presented any evidence to prove that Mike acted intentionally or recklessly to cause a death in this case. There's no confession, no evidence of a plan, and no evidence of how a death occurred. On to defense's second request for dismissal under failure to establish jurisdiction. There's no evidence to show that Mike committed second-degree murder in Maricopa County. No crime scene was physically located in Maricopa County. No witnesses to a crime in Maricopa County. No murder weapon located in Maricopa County. And no body found in Maricopa County. Finally, defense asks this court to enter a judgment of acquittal based off of the doctrine of corpus delicti. Corpus delicti is intended to safeguard against erroneous convictions. Arizona courts have recognized that jurors often take confessions or inculpatory statements at face value. And to be clear, Mike has not confessed. However, the state has elicited several statements during trial which it believes demonstrate consciousness of guilt. For example, the union killed Alissa, or come to my deathbed. The corpus delicti doctrine requires that the court find, separate and apart from Mr. Turney's statements, that the state has presented direct or circumstantial evidence that establishes a reasonable inference that Alissa is dead, and that her death resulted from Mr. Turney's conduct rather than by death, suicide, accident, or somebody else's criminal conduct. For the reasons mentioned previously, the state has failed to do that. And if the state has failed to submit adequate proof of the corpus delicti before it rests, the court should direct an acquittal. Judge, for these reasons, we are asking the court to enter a judgment of acquittal at this time. Thank you.
Thank you, Ms. Hicks. State's response.
Your Honor, we would submit that the law does not envision a person who murders someone simply because they have disposed of the body where it cannot be found, simply because they have managed to commit this crime without leaving physical evidence when there is circumstantial evidence that exists to escape being held accountable. That is not what the law envisions. Let me, first of all, and I'm really not sure which order to take this in. I'll start with the Rule 20 and talk about the corpus delicti issue afterwards. So, I'm going to read some quotes from some cases that you've read. The relevant question in a Rule 20 motion for judgment of acquittal, and I don't have these memorized, so I'm going to look at my screen and read. After viewing the evidence in a light most favorable to the prosecution, any rational trier of fact could have found the essential elements of the crime beyond a reasonable doubt. State versus Parker, 231, Arizona 391. State versus West, 226, Arizona 559. You could, all of us here who work in this area, I could list probably another 50 or 60 cases like that. Furthermore, if reasonable minds can differ on the inferences to be drawn from the evidence, a trial court has no discretion to enter a judgment of acquittal and must submit the case to the jury. So, in this phase of my response, I'm going to talk about statements the defendant has made. Because absent the corpus rule, and I don't agree with their position on it, those statements can be utilized for the purposes of Rule 20. So we have a 17-year-old girl who had family and friends. She had a cell phone. She had her mother's jewelry, which was important to her. She had makeup, which was apparently important to her, according to the testimony. She had a home. She was unhappy with the defendant. She had family and friends that she could have gone to live with. She had family and friends that, based on history, it is circumstantially, you can infer she would have contacted those people if she were alive. You could go to court. You could go to another building here and have her declared dead because she's been gone for 22 years. The last person to see her alive was the defendant. He picked her up early from school, he claimed, because he needed to discuss her plans for the summer. Discuss her plans for the summer with a young lady who lived with him. He could have discussed those plans the night before, the next day, the day after, the day after that. There was absolutely no reason to pick her up from school early unless he had an intention to get this young lady out of his life, which was apparent from that phone conversation he had with his natural son, Michael, Seth Turney. She was a fucking bitch, he said. She was a pain in his side. He could not take it any longer. My words. Inference could be drawn from the words that he spoke. A 17-year-old girl does not leave home without her cell phone. She does not leave home with no intention of returning without taking the things that were important to her. She does not leave a note saying she's running away and climb out a window, not to be seen on a video from that day. A video the defendant claimed that he had watched and there was nothing on it, and then he destroyed it. He didn't keep it for someone else to look at. He wanted people to believe that she would write a note to leave with whatever it was she took with her and climb out a window and not go through the door that she always used, so to be seen on a video surveillance. A video surveillance that, if you remember the testimony from Sarah, he turned it on when he left the house, when he wasn't there. But again, he said, I watched it. She wasn't on it. That's just not possible. He got rid of it. He claimed there was a phone call from California. Wasn't recorded. When he had calls recorded for decades, he got rid of it. If there was one, we know there was a call, but no recording of that call. When you combine the nature of their relationship, how he denigrated her over the years, how he basically said to his older son, I can't stand any more of this fucking bitch. He takes her from school when there was no reason. She had a job, Your Honor, where she would be going to work when school was over at Jack in the Box. We don't have to prove how he killed her. We don't have to prove whether he strangled her, whether he beat her, whether he struck her. All we have to prove is that he killed her. And there is circumstantial evidence that he did. All of this, he was a former deputy sheriff. So what they want you to believe, Your Honor, is that and the jury believe, is that all these efforts he made over the years was because of a genuine desire to find her. No, it was to create this image of a father who wants to find the daughter that he's murdered. He knows they're not going to find, whatever he did with her, he suspects they're not going to find her body. They're not going to hear from her because he knows that she's dead. Now let me talk about the corpus rule. They filed their motion last night. I hadn't had a chance to do a written response. So if you'll give me a little latitude here. I'm going to cite some from a case, State versus Derek Gerlaw, 134 Arizona 164. Even without, and it's on the issue of the corpus delicti rule. Even without this evidence, however, we believe the state had established the corpus delicti. The purpose, and I'm skipping here around, so if you want to go read the case to make sure this is what it says, feel free to do so. Defense can as well. What I'm getting to here is the history of this rule and why. What's the purpose of it? And remember, Ms. Hicks stood up here and said to you, the defendant has never confessed. The defendant has never admitted his guilt. The purpose of the corpus delicti rule is to prevent erroneous convictions based solely on untrue confessions. She just stood up here and said her client didn't confess. So there's the rule doesn't need to protect an untrue confession. In that Gerlaw decision, they cited Perkins and Boyce on criminal law, a Harvard Law Review article, which I would never cite, but they did. The rationale, but this language is particularly critical here in this analysis, Your Honor, because we have to understand the purpose of this rule. The rationale for the corpus delicti rule was a realization that confessions may be untrustworthy because of involuntariness due to improper police conduct or unreliability due to the mental instability of the accused. That's not even their position here. Their position is there hasn't been any police misconduct that led to an untrue confession. In the Gerlaw case, Your Honor, that defendant confessed to killing the victim in that case, but it wasn't recorded. It was 1980, they didn't record his confession. So you had a detective testifying, this is what he told me. So the issue was there evidence independent of that confession to corroborate it? Well, that's the purpose of the rule. But it doesn't serve a purpose in this case, and it doesn't apply in our factual situation. Therefore, any confession, admission, which they claim doesn't exist, any statement that this defendant made can be utilized to prove this case. Thank you.
Thank you, Mr. Immordino. Ms. Hicks, I will give you the last word.
Just a moment, Your Honor. Judge, turning first to the corpus issue, the case law says that that the term confession can be used interchangeably from statements that are made throughout the case. So we would be requesting not just, clearly there's been no confession here, but any statements that are possibly inculpatory to be suppressed. And that's based off of State v. Jones, 198 Eras 18. Judge, Mr. Imbordino stated that circumstantial evidence, that the state has presented enough circumstantial evidence that Mr. Turney has committed murder. But the only circumstantial evidence that they've presented during this trial is evidence of his character, not of a crime that's been committed. He said, you know, he was the last person to see Alissa, but we don't know that. We don't know who the last person was to see Alissa. And that's, obviously it's horrible that there is a young woman who is missing, but it's not Mr. Turney who's responsible. Finally, Mr. Imbordino mentioned that with Rule 20, the evidence must be viewed in a light most favorable to the prosecution. And while that is true, the evidence must be more than just a scintilla of evidence, which is all that the state has presented here. So thank you.
Thank you. I have considered the issues raised by the defense and the state's responses to those. Taking the corpus issue first, the court has to consider the evidence that is before this jury and exclude from that consideration the defendant's statements. While there are cases that do suggest that the corpus rule is limited to confessions, Ms. Hicks is right. There are other cases that use the term statements. So when looking at this case without the defendant's statements, the court has to make two findings. Is there a reasonable inference that Alissa is dead? Or could the jury make a reasonable inference that Alissa is dead? And the second question is does the court or the finder of fact have the ability to make a reasonable inference that Alissa's death resulted from the defendant's conduct? The court has considered the evidence presented without the defendant's statements. The court finds that there is a reasonable inference that Alissa is dead. I find that this court could make that reasonable inference and that the jury could make that reasonable inference. The second question is there a reasonable inference that Alissa's death resulted from the defendant's conduct? There is really no testimony about the defendant's conduct in relation to Alissa's death. The defendant raised Alissa, and the court is not here to decide if his parenting style was appropriate or inappropriate. The court's not even deciding if the defendant killed Alissa or not. The court is deciding whether or not a reasonable inference from the evidence that has been put before the jury, excluding his statements, shows that a reasonable inference can be made that the defendant caused or the defendant engaged in conduct that resulted in Alissa's death. The court is unable to make that finding. It is ordered granting the defendant's motion to dismiss based on the corpus delicti rule. The second question is whether or not substantial evidence exists to warrant a conviction. In some ways, I could just skip this and say the issue is moot because of my ruling on the corpus issue, but for purposes of the record, I'll make the finding anyways. There is evidence in the case. I am not here to suggest that the state has put forth no evidence. There is evidence. The court has to determine whether or not there is substantial evidence. And the evidence doesn't have to be direct evidence, it can be circumstantial evidence. There is circumstantial evidence in the case. The question then becomes, is it substantial that would warrant a conviction for second-degree murder? The court has considered the evidence and finds that substantial evidence does not exist to warrant a conviction. It's ordered granting defendant's motion for a Rule 20 judgment of acquittal. I will order the defendant released as to these charges only. Mr. Turney, you're going to be signing for a copy of your release. I'll bring the jury back in and just let them know that their jury service is over. Before we do that, anything for the record from the state?
No, sir.
Anything for the record from the defense?
No, nothing from defense. Thank you.
All right. Angela, you can bring the jury in. Please be seated. We are back on the record in State versus Turney. Let the record show the presence of counsel and the defendant and the jury. Ladies and gentlemen, during the break, I had to make some legal rulings, and as a result of my rulings, the trial is now over. You are now discharged as jurors, and the admonition is now lifted. You can talk to anybody that you want to talk to about the case, but you don't have to talk to anybody if you don't want to. I will come back to the jury room in a moment to thank you in person for your service. Sometimes the attorneys like to come back and talk to the jurors after a trial. If you want to stay and talk to them, you're welcome to do so. But if you want to just gather your things and go, you're welcome to do that as well. On behalf of the court and the parties, thank you so much for giving us your time for this trial. It was important and meaningful, and the court and the parties and the community recognize that our criminal justice system cannot function without people who are willing to do what you have done, which is give of your time and attention for purposes of sitting and listening to evidence in a case. So thank you so much for that. Please take everything with you into the jury room. Again, I'll come back in just a moment and thank you in person. Jury is now excused. Please be seated. Let the record show the presence of counsel and the defendant. Jury is not present. Anything for the record from the state? Does the state want to talk to the jury? Anything for the record from the defense?
No, Your Honor.
Does the defense want to talk to the jury?
I do if they want to. I don't. Not
Okay.
something I seek out, but if they want to, I will.
If you just stay here, I'll have Angela come and get you if and when the jury is ready, or she'll let you know that they're not interested. Angela is going to come back in and have defendant sign for a copy of his release, and we are adjourned. Thank you.
Thank you, Your Honor.
No, I know that Court TV gave me some documents. I will give them to the jury.
A little while, because she has to separate out what I gave him, like the copy that I gave him. Those two you brought down. Well, I'm going to come back. That's right. Well, go ahead. You can talk to her and arrange a day when you come back.